So very good afternoon everyone. This is CA Koushik Mukhesh. So we are now going to take up the class with regard to the Insolvency and Bankruptcy Code for the May 22 examination, because when I get 100 messages with regard to the revision request, in at least 80 we are finding a request on Insolvency and Bankruptcy Code. So therefore let me first start only with the Insolvency Bankruptcy Code directly. And by the way, recording has to be, now I am not in Hyderabad, I am in Chennai now. So I am now taking the class from Chennai. So therefore recording studio is not domestic what I have in Hyderabad. So I need to travel and I need to start. So therefore this delay. And with regard to the revision session, from today I will be having a free time of around 4 hours a day, where I can record my normal fast track lectures as well as YouTube live I will be coming. So we start with the Insolvency Bankruptcy Code for today, and 6D I will be focusing this time, because already paper number 4 last time we have taken up. So this time I am targeting more on paper number 6D. So paper 6D we will be having a full-fledged discussion on certain important areas applicable, especially the case laws. Okay, so the case laws, because those who taken the classes previously also it will be helpful for them. So planning to take first the case laws. That means, for example, if I take Insolvency and Bankruptcy Code, subject discussion will be done today. Next lecture what I will do is, for the paper 6D point of view, I will be taking up the case laws. There are around 35-40 case laws are there. We will be simplifying that. I will be showing you, and how this particular concept of Insolvency Bankruptcy Code case laws will be asked in exam. We will do a thorough research in this regard. Okay, so I will put wholehearted efforts in order to complete the important case laws for the exam, especially the points like Insolvency Bankruptcy Code, the PMLA, FEMA, that helps as well, paper number 4 as well. Okay, so in paper number 6D also, those are the common topics we will be covering, including the case laws on SURF. So in the last 1.5 months I was very busy in various ways, not one way. Some personal issues have come, and some classes are there going on. Fast track lectures have to be recorded. Now fast track lectures almost around 80-85 hours has completed. Another 10 hours is still there, we need to complete. So because of that I couldn't come live this time so early. Okay, but hope you all have completed one time of reading. This will be definitely helping you for making your revision a kickstart, or if you have already done a start for your revision, definitely that will augment your preparation. And this particular live session will be discussing majorly on the Insolvency and Bankruptcy Code. Various doubts of yours with regard to Insolvency Code, especially section number 11, section number 10A. Whenever students are reading section number 12, various doubts they are putting me a message. Sometimes I may see, I may not see because of the schedules. Therefore this time I will be sorting you all your doubts live. Whatever doubt you have with regard to the Insolvency and Bankruptcy Code, I will be covering you in this particular session, because it's important, and 15 to 18 marks you can expect in exam, 15 marks in paper 4, and 20 to 25 marks in paper 6D. A substantial portion of our concept will be filled with Insolvency Bankruptcy Code. Therefore first let us start with this particular concept. Okay, let's begin. See here, whatever you are seeing on the screen. So the division of this particular chapter, this chapter will be divided totally into 6 parts. Okay, first one will be the basics and definitions. Next one, CIRP related definitions or CIRP related basics, including definitions inside. And the next concept will be advanced aspects in CIRP, advanced aspects in CIRP. Once after that, FTCIRP, fast track corporate insolvency resolution process. And lastly and finally it will be the concept of liquidation. So let us start with the first one. Let's not go into meanings, and let's not go into the internal analysis of all these concepts and waste our time. Quickly let me revise all important concepts. Okay, from the exam point of view, whatever is important I will be covering those. Okay, so let's start. See here, what is the name of the code? The name of the code is Insolvency and the Bankruptcy Code 2016. And this particular act is applicable to entire India, including the state of Jammu and Kashmir. Assent of President obtained on 28th May 2016 and date of coming into force is 5th August 2016. Mark this important MCQ. 28th May 2016, Assent of President, 5th August 2016, date of coming into force. Hope you are clear up to here, everyone. Right. Next one. Application. Very, very important section. This is the charging section of applicability. Application. To whom this particular act will apply? The provisions of this code shall apply to companies. Okay. So shall apply to companies. Companies means which type of companies? Companies under Companies Act, company under any act. If the word company is used in Companies Act, I need not give any explanation as to what is a company, because already company is defined under Companies Act. I repeat once again, if the word company is used in Companies Act, you need not get a doubt. Which company, like that? Company means company incorporated under Companies Act. But the term company is used in Insolvency Code. Therefore, the problem is, what do we mean by company under Insolvency Code? Which companies are covered? It covers two types of companies. Companies under Companies Act or any other previous company law, or companies governed by special acts. Okay? Special acts. If a particular company, Food Corporation of India Limited, may be a company but not incorporated under Companies Act. Clear, everyone? Like that, so many companies are there which are not governed by the Companies Act. Those companies, we call these as body corporates. So act is applicable for companies as well as body corporates. Okay. Next, by 18th March 2020, Reorganization Act for the Jammu Kashmir, act is applied also to the state of Jammu and Kashmir. So act is applicable to whom? Code is applicable to whom? Companies, limited liability partnership, proprietorship, personal guarantor, individual being not being personal guarantors, any such other body incorporated under any law. That means only body incorporated under any law. Okay, any other body incorporated under any law. Everything will be covered by this particular code. Okay, so this is the first query. What is the examination issue that we need to remember in this area? When it comes to the concept of provisions of the code applicability, first one, it is applicable to companies. LLP, partnership, proprietorship, personal guarantors to the corporate debtor, individuals not being personal guarantors, such other body corporate, like that he has given the list of persons to whom this act apply. Now my question, everyone please participate and answer now. So the main point that you need to understand is, what do you mean by provisions of this code apply to these people? Provisions of this code apply to these people means these persons, whoever are covered here, will be creditors or debtors or both. Act is applicable to company. Company is a creditor or debtor. Which one? That is a very important thing that we need to learn. So this everyone will remember. Anyone who mug up the concept also will remember this. To whom the act apply means immediately he will tell company, LLP, partnership, proprietorship, personal guarantor, like that he will kill the information. But my question is, wherever you find this, the provisions of this code apply to company, LLP, partnership, proprietorship, like that list is given. All these people should stand as a debtor, should stand as a creditor, should stand as anyone. That means anyone will be applicable, or they should be only debtors or only creditors. Waiting for your answer. Hope you understood the question first. All the persons covered in the screen, these people should stand as a debtor or as a creditor or as both. Everyone. So the answer behind this is, the person who is standing in this position must be a debtor. Applicability of this act means applicability to the debtors. Sir, how can you understand like that? Where he said that it should be a debtor? Shall I show you where it is debtor? Listen. Personal guarantor to the corporate debtor he used. What do you mean personal guarantor to the corporate debtor? Corporate debtor is there. Not only the corporate debtor being a company, any person who gave guarantee to the outsider on behalf of corporate debtor, if corporate debtor fails to pay, he has to pay. Personal guarantor don't stand in the position of a creditor at any point of time. Guarantors are always secondary debtors. Whenever you read the concept of indemnity guarantee in Contract Act, there is one very clear point saying that there will be three parties in every guarantee contract. Principal debtor, or first one creditor, second one principal debtor, third one is a surety. Surety is also called as a guarantee or a guarantor, we will call. Okay, guarantor will pay if the original principal debtor fails to repay. That means the guarantor stands in which capacity? Debtor capacity. All these are the provisions of this code are applicable to debtors being company or LLP or a partnership or a proprietorship or a personal guarantor or individuals not being personal guarantors or any other body. So therefore this is not from the creditor point of view, this is from the debtor point of view. This is one answer. Next issue. Next issue. So the next point is definitions regarding the Insolvency and Bankruptcy Code. What are all the important definitions that we need to understand from the point of view of Insolvency and Bankruptcy Code is the next query. Okay. First one, definitions. Corporate debtor. Corporate debtor. Why we need to read the definition of corporate debtor? Because in order to apply the Insolvency and Bankruptcy Code, first one, corporate debtor should commit a default either to a financial creditor or to a operational creditor of a minimum amount of rupees 1 crore. He need to get defaulted. Who? Corporate debtor must be defaulted to the financial creditors or to the operational creditors of a minimum amount of rupees 1 crore. That means from 1 crore onwards it starts. If 1 crore attracted, you can start filing applications for corporate insolvency resolution process. Therefore, we need to know who is a corporate debtor, who is a financial creditor, who is a operational creditor. And minimum what should be there for 1 crore? Default should be there. So we need to understand what is the important definition called as a default. See here. Who is a corporate debtor? Corporate debtor means a corporate person who owes debt to any person. Corporate debtor means a corporate person. That means it is a person having corporate characters. Who owes a debt? Who owes a debt? To whom? Any person. What you understand from this? Debtor means a corporate person. This corporate debtor should be any person who is having a corporate characters. Corporate person. This corporate person owes debt to any person. That means who he is? He is a debtor. He is a creditor. Creditor can be any person. Creditor can be individual, HUF, anyone it can be. But debtor must be a corporate person to apply CIRP. CIRP means for Corporate Insolvency Resolution Process. To apply Corporate Insolvency Resolution Process, the person who is included should be a corporate person. Okay. Next issue. Corporate debtor is a corporate person. But who is a corporate person? Corporate person means number 1, company, LLP, any entity incorporated with limited liability. Example, cooperative society. Cooperative society, Krishna Dairy Development Cooperative Union Limited, limited liability. Entity, if it is having a limited liability, yes, it will get applied. Okay, any entity incorporated with a limited liability. We are reading which definition? Corporate person. Who is a corporate person? Corporate person means companies, LLP, or any entity incorporated with limited liability. Sir, corporate person is a definition which is read in the point of view of a debtor. So corporate debtor means a corporate person. Who is a corporate person? Corporate person means a company, LLP. Sir, you said corporate debtor is a corporate person. That means corporate person is whom? It should be a debtor. Debtor can be, you said, individual, HUF, LLP, all these things you said. But here you are telling only company, LLP and any entity. We are reading CIRP. That is a definition applicable for entire act. In this act, there are two portions. Corporate insolvency, individual insolvency. Okay. So individual insolvency, guarantors, all these concepts will come. So we are reading corporate insolvency. So only corporates will come. Debtors being corporates only will be included. So anyway, corporate person means a company under Companies Act, LLP, or any entity incorporated with a limited liability, but does not include a financial service provider. Therefore, debtor being banks, debtor being financial institutions, debtor being the NBFCs, debtor being the insurance companies will not be governed by the provisions of this law, because all those financial service providers are governed by financial sector regulators like banks by RBI, financial institutions by RBI, NBFCs by RBI, insurance company by IRDA. Separate authorities are governing them. This law does not apply to them. That means if a bank is a creditor, act apply to it. If a bank is a debtor, this act does not apply. Next, corporate debtor means a corporate person who owes a debt. What is a debt? Debt means liability or obligation in respect of a claim which is due from any person and includes a financial debt and a operational debt. So again, debt means what? Debt is a liability or an obligation. Liability or an obligation in respect of a claim. Very, very important term in the act is claim. What is this claim? Claim means X is liable to Y to pay some amount. That itself is not enough to charge on IBC. You should claim. That means you should tell Mr. X, you are liable to pay me 5 crore. I am now claiming my amount, pay me. If you ask only, they will start making the IBC applicable. That means if you don't claim your amount directly without claiming, seeing your balance sheet, no creditor will be repaid under insolvency code. That's why public announcement will be given under section number 15 such that everyone will make their individual claim. Keep it in mind always. Beyond this, I can't waste your time. So, liability or obligation in respect of a claim. Claim means pay me. You should ask, then only payment will come. If you sit silent, no payment will be done under insolvency code. If you don't claim, it will not become debt. When it is not a debt, it will not become a financial debt or operational debt. Once it is not a financial debt or operational debt, outer party will not become a corporate debtor to you. If no corporate debtor, there is no insolvency code. Therefore, try to understand. Unless and until you claim, payments will not be made. And includes two types of debts. There are two types of debts in this act. One is a financial debt, another one is a operational debt. Okay. Person. Person includes, not means. Okay. Person. Person in whose context? Person. Jing, 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 jing. Jing, jing. What it is? Person should be read from the point of view of a creditor. Creditor can be whom? Creditor can be individual, creditor can be HUF, creditor can be company, creditor can be trust, creditor can be LLP, creditor can be partnership, creditor can also be a foreign creditor. Okay, this is the point. Creditor can also be a foreign creditor. This is the first point that you need to understand. So these are the 4 definitions. Once everyone participating say yes, I will be going into the next part. Waiting for your yes. Once you say yes, I will go into next 5, 6, 7, 8, 9. Many definitions are there. I will go into that. Okay. Yeah. Next issue. 5, 6, 7, 8, 9. We need to cover these in 2 minutes. Let's cover. 1, 2, 3, start. Person resident outside India means a person who is not a resident in India. Other than person resident in India is a person resident outside India. Who is a person resident in India? Same as FEMA. Now, creditor. There are 2 types of creditor. Financial creditor, operational creditor. First, there should be creditor. Creditor means what? Creditor means a person to whom the debt is owed. Okay. There are 2 kinds of creditors. Financial creditor, operational creditor. There are 2 types of financial and operational again. Financial, operational. These people can be secured. So these people can be secured. These people can also be unsecured. And a decree holder. Sir, what is a decree holder? I am telling that you owe me 50,000 or 5 crores. I said you are owing me 5 crore. You are telling I am not owing to you. Case is under the court. As of now, first 2 hearings are in favor of me. I will be called as a decree holder being a creditor. I will also be included. Okay. Now listen carefully. First, Creditor means any person to whom the debt is owed and includes financial creditor, operational creditor. That financial and operational can be unsecured or secured, may also be a decree holder. Next issue, financial creditor. Who is that? Financial creditor. Financial creditor means any person to whom financial debt is owed. Financial debt is owed. When the financial debt is owed to you, you will be called as a financial creditor. Okay. Not only that, a person to whom such a debt has been legally assigned or transferred to. What do you mean legal assignment? I am a financial creditor to a company. Let me give an example. Fastly, please, let's not waste time. X Limited is there, Y Limited is there, Z Limited is there. X Limited gave loan to Y Limited. X Limited took loan from Z Limited. Okay, triangle love story. X to Y, Z to X. Okay, this is what the transaction happening. Now listen carefully. X gave 1 crore rupee to Y. Z gave, for simplicity sake, 1 crore to X. Now really try to understand the transaction. Y Limited is owing to X Limited. Okay, X Limited is owing to Z Limited. What X Limited has done? X Limited said that Z Limited, you need to get the repayment or not? I will do one thing. I will transfer my right to recover from Y Limited to you. Originally, X Limited is a corporate debtor to Z Limited. And X Limited is a financial creditor to Y Limited. Now what they will do? They will relinquish their right. Who will relinquish the right? X Limited relinquishes the right. What X Limited will tell? Z Limited, I have to pay you 1 crore. Na? I will do one thing. I will assign this debt to you. That means right of recovery of this 1 crore will stop to me and it will stand in your hand. That means Z Limited has become financial creditor in the middle. Originally he is not a financial creditor to Y Limited. Okay, suddenly he steps into the shoes of X Limited. X Limited will go out, he will become. That's called as a legal assignment. If you didn't understand, go back to the lecture and listen carefully. I can't waste the time. Operational creditor, same concept. Here financial debt is owed, here operational debt is owed. Assignment concept is same. That's all. Answer completed. Sir, we have completed 5, 6, 7, 8, 9 definitions. One yes, everyone in the session will be going into the next part. One person is asking about, sorry, what is the difference between person and a creditor definition? Creditor la person will be there. All persons may be creditor. Technically, if you want to understand, if you read creditor definition, creditor means any person. Means what? Whatever the list of persons we gave, anyone can become the creditor. That's the idea. That's the difference. Mr. Vikas, did you understand what I said? Waiting for your yes. Maybe he is not there. Next. Definition number 10, 11, 12, 13, 14. Let's try to understand. Listen carefully. Next definitions are 10, 11, 12, 13 and 14. Claim. First definition is claim. Most important definition for the entire chapter, if there is anything, that is a claim. Most important definition for entire chapter. Not from exams point of view, from the understanding point of view of insolvency code. If we don't know what is the definition of a claim, it becomes a nonsense of understanding the remaining chapter. Take it for granted. Okay? Because the word debt itself factors in a word called as a claim. Unless and until you make a claim, debt will not be there. Unless and debt is there, where IBC? IBC stems out of the concept of debt. That debt will come because of claim. That means who is more important? Claim is the important thing. Unless and until you know what is the meaning of claim, you are reading nonsense in insolvency code. That means you are just mugging up the concept without understanding what really he want to convey. Because the term claim is the sole song. for insolvency code. Claim is a sole song for the insolvency code. Unless and until we really see the definition importance, we can't really appreciate what is the idea behind the insolvency code. Okay, sorry, let us start with the concept. Okay, see here, claim means two things. For this I will spend 5 minutes time. Remaining I will cope up with the time limit. This it will take some time. I will explain. Claim means a right to payment. Okay, not only right to payment, right to remedy for a breach of contract if such breach gives rise to a payment. Okay, right to payment, whether or not such right is reduced to judgment or fixed, legal or equitable, disputed or undisputed, secured or unsecured. Okay, next, right to remedy for a breach of contract if such a breach gives rise to a right to payment, whether or not such right is reduced to judgment or fixed, disputed or undisputed, matured or unmatured, secured or unsecured. Like that he said certain things. First, we need to first understand certain important terms here. Whenever there is a debt, one person will claim his debt. Hey, you have to pay me. Creditor. Debtor will tell that, hey, you have to pay you only some amount. Dispute is going on. Or debtor may tell that, okay sir, I am really indebted to you, I will pay. It may be disputed or undisputed. Once it is disputed, it will go to the court for a judgment. Court can tell that, I have 5 crore you are claiming, only 2 crores is the amount. 5 crores is fixed amount. It may be reduced to judgment, it may be a fixed amount. Okay, once disputed, it may be reduced to the judgment of the court, or if it is undisputed, it will be fixed amount. Very good. Next issue, secured or unsecured. That amount can be either that claim on which you are, the debt on which you are making a claim may be a secured amount, maybe unsecured amount, maybe a secured amount or a unsecured amount, maybe a secured amount or unsecured amount. Next one, whether or not such a right is legal or equitable. Legal or what sir? Equitable. This we will understand when we go into the concept. There the words will come, there I can relate this. Next, this point we understood. Right to the payment, whether or not such right is reduced to the judgment. But you read first this one, later this one, later this one, lastly this one. Like that if you read, you can get a clarity. Right to the payment, whether or not such right is disputed or undisputed. Immediately brain will intimate you there is some linking concept here. Once disputed, it may be reduced to judgment. If it is undisputed, fixed amount will be taken up. Next one, it may be legal, it may be equitable. It may be legal, it may be equitable. Or it may be secured, it may be unsecured. Sir, what is this legal equitable, sir? After that, if you forget, he will be gone. So explain now itself. I will explain. Legal or equitable debts. Try to understand clearly. Operational debt can come either in a legal form or even a illegal equitable form. Not illegal. Legal or equitable form. Sir, what is this equitable form? Legal form means on a documentation, everything was entered. Mr. Koushik Mukhesh, you gave me loan of 10 crore. Mr. A, you have taken loan. Everything is legalized on a stamp paper and brought into the records. These are called as a legal debts claim. Claim on a legal debt. Claim on a equitable debt. Equitable debt will be there mostly on the operational debts. Mostly on what debts, sir? Operational debt. Exceptional cases of financial debts can have a equitable debt, but generally it will be only on operational debt. Do you know what is an equitable debt? Equitable debt means a justified debt, also called as law of tort. Law of tort. Sir, what is this law of tort? What is this law of tort? Sir, sound issue is coming, huh? Some people are informing. Sir, is there any sound issue? Please intimate me if any. Some people are putting me a message that there is some sound issue. Please. If there is any, please intimate me. Only for them or everyone? From my side, audio devices are working well. Okay, I can continue then. Okay. So, legal and equitable. Equitable means a law of tort. So, tort is a word which came from another English word. This is the main word. Tort is a main word. Tort means to disturb. Tort means what, sir? To disturb. Okay. To disturb. Whenever you make a disturbance, tort has resulted in another word called as a distortion. Distort has become a present continuous tense distortion. Okay, so it become a verb which is having a present continuous statement called as a distortion. Like that, extortion. Tort is a word which is called as a disturbance, hurting. Law of tort is a concept. Those are all comes under equitable debts. Sir, what is law of tort? Explanation? Yes, I will tell you. What is this equitable debt? What is this law of tort? What about this? Listen. A person is going on a bike. A person is coming on a car. Person coming on the car hit the person on the bike. He was badly injured. He was badly injured. Now listen carefully to the point. Mr. B on the bike, immediately he stood up, almost wounded severely, but he could stand by God's grace. Immediately said that let's go to the police station. Nearby police station only accident occurred. Clear everyone? So nearby police station only accident occurred. Immediately they said that, sir, I was severely injured because of his rash driving. For the tort committed against me, he should pay me 5 lakh. We said that. He should pay me 5 lakh. For the accident that was caused to me, hospital cost, all these things will be there. Na? Sir, hospital cost, all these things will be there. It is justified for the person who committed accident to pay me. A overaction, you committed accident and you are going out. So therefore, lawmaker has clearly said that these are called as equitable debts. That will also make you a creditor. That will also make you a creditor. Equitable debts are those debts which comes place or which takes place on the basis of humanity. Out of the tort it will get generated. So now this is one example. Like this, if company commit any kind of company is an artificial person, it can't commit accident. So company commit any kind of breach of a contract. What it conducts? Breach of a contract. Because of breach, two types of situations will come. Number one, because of breach, contract will be cancelled. Because of cancelling the contract, I will get some loss. That loss company has to repay. If that amount of loss caused to the other party because of company is exceeding 1 crore, 1 crore or exceeds 1 crore, it becomes an equitable debt on the face of the company. Yes, equitable debt on the face of the company. That means for cancelling the contract, other person has suffered something. Equitable debt. Along with that, other person, what he will do, because you cancel the contract, I lost an opportunity to sell to other party, you should also pay me damages. These damages are various types: ordinary damages, special damages, vindictive damages, exemplary damages, okay, or remote damages, liquidated damages, penalty damages. Like that in Contract Act he will speak, section number 72 of the contract. So equitable debts are those debts which are not written in a legal form. Sir, accident will be occurred by writing agreement. Suddenly it occurred, but you are liable to pay him for the hospital charges. Likewise, if company commit any aggrievance on another party for which the other party makes a complaint against you for recovery, that becomes a equitable debt. Company will enter into contracts with various parties and breach the contracts. At that time, equitable debts will come. Okay, so why I explained so much about this claim means, in one of the case law, it was tested in one of the recent attempt. Okay, 2021 attempt, like that one of the question was asked as a case law from the equitable debt. Therefore, I am taking so much time to explain what is this equitable debt concept. Next. Sir, okay, sir, right to payment, okay. Then what is the second concept? Right to remedy for the breach of contract. Right to remedy for the breach of contract. Okay, whenever there is a breach of contract, it gives rise to a debt. Already I said. If such breach gives rise to a payment. If such breach gives rise to a payment. Okay, whether or not such right is reduced to judgment or fixed, disputed or undisputed, matured or unmatured, and secured or unsecured. Secured or unsecured. Next one. See here. whenever there is a breach of contract, no one will enter into agreement. Koushik Mukhesh, I will enter into contract with you, which I will breach in future. No fool will enter like that. Therefore, there is no concept called as legal or equitable breach. Breach itself is not good. Then what is this legal breach, equitable breach? Breach gives rise to equitable rights. Okay, that's why the term legal equitable will not be found here. Sir, matured and unmatured is not there, sir, in the right to payment, but here it came. What is this going on then? Listen carefully, bhaiya. The point is, reduced to judgment or fixed the same. Okay, dispute whenever breach comes, matter will be into breach is always disputed. Sometimes it may be undisputed. If it is disputed, reduced to judgment. Undisputed, it will be fixed. Secured or unsecured debt, on that there is a breach. Okay. Now the point is, matured and unmatured, why it came? Now every one of you should understand one thing. In this insolvency bankruptcy code, creditor will get the rights against the debtor when there is a default. What is a default? Default means the due date has come but you didn't pay. That means maturity has come but you didn't pay. That means maturity is the essential element to have a default. Okay, right to the payment will come only on maturity. Therefore, before maturity, claiming for IBC is not possible. Therefore, the concept of matured and unmatured will not be there. But a breach of contract can be made even before the date of maturity. That's called as an anticipatory breach. Therefore, unmatured is also coming here. This is the whole idea of the story regarding the definition of the term claim. Now, you people should tell, understood or not. Everyone, hope you understood the concept up to here, and whether you understood the claim definition or not properly now. Clear? Next issue. Default. Default means non-payment of any debt. When whole or part or installment of a debt is not paid to the corporate credit. Corporate is not paid by the corporate debtor. Which amount? Either whole or part or installment of a debt become due and payable means what? Already it has come for maturity. Next. Dispute definition we are not going to read now. Section number 8, subsection 2, clause A. When we come there, we will define. Corporate debtor and corporate guarantor, personal guarantor. Corporate guarantor means guarantor in the form of a company. Personal guarantor means guarantor in the form of an individual. That's all. Okay, completed. Next issue. Types of debts under the insolvency code. Types of debt under the insolvency code. Okay. Listen carefully to the point. Types of debts under insolvency code. There are two types of debts. One is financial debt. Another one is a operational debt. Financial debt and a operational debt. Financial debt means a debt along with interest, if any, which is disbursed against the consideration for time value of money. Which is disbursed against the consideration for time value of money. And includes money borrowed for interest, money raised by acceptance credit facility, money raised by issue of bonds, debentures, liability with respect to finance lease or hire purchase, receivable sold or discounted, amount raised for any other transaction, any derivative transaction, indemnity and guarantee obligation. Like that, so many definitions are given. Let us understand one by one clearly but very, very fast. See here. First point. Financial debt means any debt along with interest, if any. Whenever we give a loan, we expect some return or not? Whenever we give loans to some party, we will expect some return or not? That return of interest is mandatory, if any. That means, is it mandatory to charge a interest or it is not mandatory? Interest charging or return is mandatory to call a financial debt. Getting return is mandatory or optional? Give an answer, everyone. So, return is optional or mandatory in order to have a financial debt. So, Here he has used very clearly. Here he has used very clearly. Thank you. No need. Thank you. Here he has used very clearly the detail along with the interest if any. That means return is mandatory. Return for that is optional or mandatory. It is optional. It is optional. Like this you should not think. Do you know why? Debt along with interest is if any. Return is if any. That's why he clearly said that disbursed again as a consideration for time value of money. Means what? Return expectation is should be there. Interest may be there, may not be there. Do you know why he said like that? Interest if any. Debt includes bonds. Bonds include zero coupon bonds. Zero coupon bonds like interest will not be there, but return will be there. Time value of money will be there. Game over. Now reply. Not mandatory, not mandatory, not necessary, optional, optional. Okay. Satisfied everyone in the class? Happy? So next issue. So debt along with interest if any, which is disbursed again as a consideration for a time value of money. So time value of money element is required. But interest may be there, may not be there, but return should be there. That means, what is the lawmaker's intention? If you are giving 100 rupees and if you are taking 100 rupees after 1 year, for rich kids like you, IBC is not to support. IBC will support the innocent borrowers who are having some return expectation on the debts. Okay, money borrowed for interest, normal borrowing. Money raised by acceptance credit facility. These are the classic examples of your credit card. You are accepting credit. You may use, you may not use. If you use, debt will start. Next one, bonds and debentures and finance lease, factoring services. This point we will separately discuss. This is a real estate transaction. Any derivative transaction, if you enter to with the stock exchange and if you are not paying the deposits etc., you become a financial debt. Indemnity and guarantee obligation, obviously guarantor is a surety, surety will become a debtor, and debtor will, if it is on a financial debt, you will become a financial creditor, you will become a corporate debtor and it becomes a financial debt. If you are giving a guarantee to a financial debt of some person, you will also become a financial debtor. Then that means a corporate debtor on a financial debt. Next, operational debt. What is operational debt? Operational debt means a claim in respect of provision of goods or services including employment or dues to the CGST or a local authority. Now I will ask you one question, answer. The word claim is not there in financial debt, but the word claim is there in operational debt. I will give you 1 minute time maximum to understand this. Anyone, if you want to answer, you can. Feel free to give an answer for this. Why the word claim is not there in the financial debt concept? Why it is there in operational debt? Don't give this answer. Sir, already in the financial debt the word debt is used. In operational debt he didn't use. He might use the word debt. Operational debt means a debt he can use. Why he is using operational debt means a claim? Sir, this is a revision class. Already you might have completed. With that liberty I am asking this question. Answer. Don't waste my time. Answer. Raghunandana Sharma. Okay, operational debtor need to claim to apply for CIRP. Anyone has to claim. Why only operational debtor? Why definition use the word claim? Operational debtors have right for their dues, so claim is used. Okay. MS Rohit, no. Anyone can go for a settlement, not just operational. They have to send demand notice. What is the link between demand notice and a claim? Oh, demand notice is a claim. No. Demand notice is not a claim. If that be the claim, they will directly tell that it's a claim. Demand notice is only a notice demanding the payment of debt. It may be disputed, it may be undisputed later. Financial debtors is an agreement from first only, sir. Any other answer? Listen carefully. Do you know why? Surprisingly, I didn't get even one correct answer for this. Surprisingly, without knowing this logic, how can you read the remaining parts of insolvency code? That's a main perplexing issue now. How can you understand the remaining IBC without knowing that? Let me explain you an important point in this connection. Maybe after that you can understand. See here, who can make an application? Section 7. FC can make, jointly with other FCs can make, or any other person on behalf of FC can make. Same like this, you can't see a point in financial operational credit. When section 9 is there, section 9, who will make an application? Section 9 shall operate after expiry of 10 days from the date of delivery of notice under section 8. And OC does not receive any payment. What will happen? Format of application point, form 5. Okay, they will apply to whom? NCLT. Who will apply? Operational creditor will apply. Operational creditor or jointly with other operational creditors or any other person on behalf of operational creditor. Like that language is not used for operational creditors. This language is used only for whom? Financial creditors. Did you get the logic, everyone? Now listen carefully. When application is safeguards to other financial creditors, remember this point. This is a proviso below section number 7 subsection number 1. Default includes a default in respect of financial debt owed not only to the applicant financial creditor but to any other financial creditor of corporate debtor. Means what? Whenever default is committed to one financial debtor, okay, in respect of one financial debt to one financial creditor, and if that one financial creditor bought a CIRP, that CIRP will cover all the defaulted financial creditors though they didn't claim separately. But such kind of defense is not given to the operational creditors. Therefore, operational creditors independently, everyone has to make their claim. Here, if one financial creditor or joint financial creditor put a petition, it covers other financial creditors also, though they are not the applicants. Not only the applicant financial creditors, other defaulted financial creditors also will be brought into the net. That is not possible for operational creditor. Means what? Every operational creditor, each and everyone has to claim independently once again. This is the answer. No other story other than this. Sir, insolvency and bankruptcy code, the point is once I start, I can't control myself because so many concepts will be coming inside. They will stem out of each and every point. Therefore, never I tried this stunt. But today, definitely, sir, another 1 hour I will complete all the IBC concepts, important concepts, everything I will complete. Because I literally love this, because we are now practicing on this, we are doing this, we qualified this exam. After doing all these things, we know what really this particular act of insolvency code is all about. Sorry, anyway, hope everyone understood the concept why operational creditors has to claim. I want an answer, everyone. Yes or no? Understood the concept, everyone? Okay, yeah. Next issue. Operational debt means a claim. Everyone has to claim. There need not be, everyone need not claim. If one person claim and starts CIRP, others will automatically come inside. Do you know why others will be automatically coming inside? Anyway, committee of creditors will be formed. And financial creditors are less in number. Not like operational creditors. Okay. Next. So, operational debt means a claim in respect of provision of goods or services including employment or dues to CGST local authority. If you fail to pay taxes properly, if you fail to pay dues and duties and cess etc. to the local authority, gone. You will become the corporate debtor. That government will become the operational creditor, and your debt becomes an operational debt. You may be brought subjected to the provisions of CIRP. Next issue. Next. Charging sections are starting. Everyone, please. Sir, I should not see anyone just seeing. Please listen carefully. Listen to the concept. Don't go from the live, or don't even come to the live. If you go out, you can go out. If you want to come, you can come. But sit, listen. From here, the concepts will take a severe turn like this. It's a U-turn concepts totally. Next 10-15 minutes. Very, very important, because I am going to cover section number 7, 8, 9, 10. 4 core sections of insolvency code we are going to cover. Okay. If you want to leave, you can leave. If you want to join, you can join now. But later in the middle, if you join, you can't understand anything. Okay. So please listen. In the live, complete it. After that, you can't listen. Time will not be sufficient. Okay. See here. Section numbers 4, 6, 11 we will discuss later. There is an amendment to this. Therefore, 11 I will discuss separately. So 4, 6. Let's first complete 4. This part, which part? CIRP part, shall apply to the matters relating to insolvency and liquidation of corporate persons. Not only insolvency, liquidation is also covered. When the minimum amount of default is 1 lakh. Sir, what is this 1 lakh? That's why I have given note below. As per proviso to section 4, central government can increase the limit to how much? 1 crore. Therefore, instead of this 1 lakh, now it will be 1 crore. Don't strike this 1 lakh. In the Bare Act also 1 lakh is there. As of now, government increased it to 1 crore. That means minimum default amount should be 1 crore. Okay, this is the point. MCA by notification dated 24/3/2020 in excess of powers under section 4 has increased the threshold to 1 crore from existing 1 lakh. Next, persons who can initiate the CIRP. Okay, first, what is the precondition to start CIRP? Default should be committed. Who can initiate CIRP? Operational, financial, corporate debtor itself. Next one. Section 11 we will discuss later. Section number 7. Important. At least now you would have recognized the importance of section number 7. Okay. Okay. Let me come back. Start. Who can make an application? One financial creditor itself, or jointly with others, or any other person on behalf. Any other person on behalf. Remember this. AP1 I am writing here. AP1. What is this AP1 or AR1? AR1 I will write. AR1 means authorized representative type 1. There are 6 kinds of authorized representatives under insolvency code. 6 types. The first type will be authorized representative type 1 under section number 7. Any person representing on behalf of the financial creditor for putting an application for CIRP under section number 7 against a corporate debtor when the default has occurred. This is AR category 1. AR plus second category will be there. Okay. When there is a syndicate financing under section number 21 subsection number 3, whenever there is a syndicate financing, that syndicate will have 2-3 members inside. Syndicate financing, consortium lending concept. There 5-6 creditors will be there inside the consortium. Each and every person will have each and every authorized representative, type 2 of authorized representative. Sometimes the notice, or sometimes when there is a consortium lending, all the consortium lenders will form a syndicate and they will fix one particular trustee for all of them. That will be the authorized representative type number 3. Whenever the financial creditors are in the form of a securities under section number 21 subsection number 6A clause number A, as per 21 6A clause A, they will clearly tell that whenever there is a securities or debentures issued by the company, at that time an authorized representative will be appointed. Popularly we call him as a debenture trustee. That will be authorized category number 4. Number 5, whenever the whenever the debts are in the form of creditors exceeding such number as may be issued, we will read in section number 21 subsection number 6A clause number B, that will be authorized category number 5. And last category, minors are insolvent creditors are there. For them an executor or a guardian will be appointed. That will be authorized category number 6. All these are governed by section number 21. Hope you understood that there is a concept called as authorized representative. These authorized representatives should act in accordance with the guidance and guidelines given by the creditor, governed by section number 25 capital A of the Insolvency Code, amendment in the year 2019. Here? Okay. This is the first point that we need to understand. Okay. So authorized representatives, there are so many concepts are there in authorized representative. 6D paper la, like anything he's asking the questions from authorized representative. Last attempt to previous attempt to previous attempt to 4 marks came from authorized representatives. Okay. Let's concentrate this. Application by whom? FC itself or jointly or any other person on behalf. Application to whom? Application to a authorized, adjudicating authority. Adjudicating authority will be obviously NCLT. Okay. When application default occurred. Safeguard. Just now I told you. Not only the applicant creditor, already other financial creditors also will be protected. Form number 1. Next one. jointly with other financial creditors. Sir, joint petition is optional or mandatory? It is generally optional, but it is mandatory in special cases. In which cases it is mandatory? In section number 21, subsection 6A, clause A and B, it is mandatory. This we will discuss when we come to section 21, not now. Okay. Second case I will discuss now. In financial creditor definition, I left one point. I said that we will discuss in section 7. This is the point. Listen carefully. Whenever real estate transactions are happening, which transaction? Real estate transaction, there will be two persons inside. One will be the promoter or builder or developer, whatever you call. This person will collect amount from various home buyers. For example, Koushik Mukhesh want to buy a plot in a particular area that is ventured by a person called as a My Home. Generally, My Home will not do this. Example, say popular name I am taking. My Home, Aditya Builders, Aditya Homes, Aparna Constructions, like this. Some person is there. To them, I will give some money as an advance. They are going to construct in the next week. Sinkustapana, Bhumi Puja is going to be done in the next week. I will be giving some advance payment to them. Token advance they will call 2 lakh, 1 lakh, 5 lakh, 10 lakh, 1 crore, some amount depending on the value of the original property. Value of the property is, let's say for example, 2 crores. They are asking 20 lakhs as a token advance. Now I will give 20 lakhs token advance to the promoter. Promoter will take 20 lakh from me. Like the 1,000 persons are there, 1,000 apartments are there. 1,000 portions are there. So 1,000 portions, so 1,000 persons came, hot cakes they were sold. 1,000 into 20 lakh. He will be getting 20,000 lakhs. 200 crore amount was collected from them. This 200 crores, what he has to do? This person has to use this 20 crore for the purpose of the construction. For the purpose of the construction. So now answer my question clearly. If home buyers would not give this 200 crore, you use the 200 crore to start your venture. If home buyers are not giving this particular 200 crores, from where you would have got this? You would have got this through borrowing. Hope you are understanding. If home buyers are not giving the promoters this particular amount of advance, then from where you would have brought this amount? You would have brought this amount by way of a borrowing. By way of a borrowing. Therefore, definition said that any amount raised from an allotee under real estate project shall be deemed to be an amount having commercial effect of borrowing. Really you didn't borrow, but you escaped borrowing because of we giving the money to you. Therefore, we are also lending you the money. You are a borrower. Therefore, you become a financial creditor. So, whenever real estate creditors are there, that means home buyers will become the financial creditors. When home buyers will become a financial creditors, if home buyer has given some advance to that particular party and that advance is not utilized within the time for the construction, the due date is crossed for the construction of the building, from the very next day you will get the status of a financial creditor. The venturer being My Home or Aparna Constructions or Aditya Homes will become a corporate debtor to you. In that case, how many financial creditors should put a complaint? Real estate allottees not less than 100 allottees of the same project or not less than 10% of the allottees of same project, whichever is less. These people must put a complaint. Technically, do you understand what does it mean? If a financial creditor default is 1 crore, default is 1 crore, that one financial creditor can put a complaint or not? But in real estate transactions, answer is no. Do you know why this was like this? Must and should joint application. Sir, I am Koushik Mukhesh, sir. I purchased a plot worth 5 crores, sir. I paid advance of 1 crore, sir. That advance was taken by him. He is enjoying like anything, sir. Only your property. Yeah? All the persons inside this venture. No, sir. Only mine. You can't put a complaint under insolvency code. Why? 100 allottees required or not less than 10% of the allottees are required. Sir, we are having 2,000 allottees. 10% means 200. From where I will bring? Or 100 minimum. From where I will bring? If you can't bring, you can't make a complaint here. Okay, you can't make a complaint. You resort to some other way. Sir, not as a home buyer, I will normally file a complaint under this way. Financial creditor itself. No, you cannot make. If you are a real estate allottee who want to file a complaint, only joint petition is mandatory. Individually, you can't make. Do you know why government has said like that? Are a house property values, easily it will cross 1 crore. That's why. Sir, everyone understood the concept clearly? Everyone understood the concept clearly? Everyone understood the concept clearly? Next issue. Attachments to the application. What attachments the financial creditor has to put? Record of default, because default is the prima facie thing. Name of RP, who will act as an IRP, any other information. Now you will send it to AA. AA will take 14 days. 14 days it should take a decision whether to accept or reject. But this 14 days is recommendatory only. Recommendatory, not mandatory. Do you know what does it mean? Whenever time limits are given in an act, those are mandatory only for us, not for government. Okay, 14 days, it can also go beyond 14 days. Okay, next, grounds of admission. On what grounds they will admit the petition, on what grounds they will reject the petition. First, grounds of admission. Default has occurred. Okay, admission of application is complete. First, default has occurred. Application form 1 is complete and no disciplinary proceedings against the RP. Grounds of rejection, just opposite. Default not committed, application incomplete, disciplinary proceedings pending. In such case, I will reject the application. But application will not be rejected. It is a rectifiable default defect in the application form. You have to rectify within a time of 7 days. Once the application is accepted, okay, CIRP will commence from the date of admission of your application. If the application is admitted, communicate to FC and CD. If it is rejected, only to FC. Completed. We are now coming into next section called as section number 8. Hope everyone understood up to here clearly. So hope everyone understood the point clearly up to here. I am going into the next one, section number 8. See here, section number 8. Section number 8 is not a section directly going into the NCLT. First, section 8 is a operational creditor insolvency resolution. He will try to resolve insolvency. If he could not resolve under section 8, then only section 9 will come. Section 9 must bypass through section 8. Direct bypass from 7 to 9 not possible. It should go through section number 8. 8 is a mandatory provision. You can't escape section number 8. What you are reading here, you cannot escape that. It is a mandatory provision. Okay, so let's see. Option to the operational creditor. First, sir, why this provision was set? So first let us read. Okay, rather than going into the logics, let us first read. See here, operational creditor option available. Operational creditor, upon occurrence of a default, deliver a demand notice. Deliver which notice, sir? Demand notice of what? Unpaid operational debt. Demand notice means I will ask them, creditor, I am a operational creditor. I will demand the debtor, corporate debtor. You have to pay me some amount. Pay me. I will issue a demand notice. I will issue which notice, sir? Demand notice. The demand notice will go to whom? Will go to the corporate debtor. On receipt of this, corporate debtor within 7 days of receipt of demand notice, bring to the notice of operational creditor. Bring to the notice of whom, sir? Operation creditor. He should bring to the notice of operation creditor existence of a dispute or record of pendency or suit or arbitration proceedings filed before the receipt of such notice, or payment of unpaid operational debt by sending attested copy of e-transfer or encashed the check. What is this? A minute time given to you. Please read this chart only properly first. Read the chart. More than that is not enough, not required. Completed? Let's start. See here. First, operational creditor will not directly go to the NCLT. First, he will try to resolve within the corporate debtor. Why within the corporate debtor he will try to resolve? Corporate debtor will be an employee. Worker is also a corporate debtor. Workers and employees are also corporate debtor. If you fail to pay the salaries to your workmen exceeding 1 crore, they can also move an application for CIRP. See, worker is a person inside my factory. Okay, or employee is a person inside my administration staff or a clerical staff. Administration staff, if they have any problem, they can come to me directly. Why you are directly go to some third party? Try to resolve within ourselves. Therefore, with that intention, I am trying to give you a demand notice. Okay, the creditors, operational creditor will first give a demand notice to the unpaid operational debt to the corporate debtor. Corporate debtor, you have some unpaid operational debt. Hope you remember this. So, therefore, make us the payment immediately. Okay. Corporate debtor can give two types of reply. Reply number 1, he will tell I will pay. Okay. Reply he may give I will not pay. I will not pay. Yes, I will not pay. Why you will not pay? There is already an existence of dispute. Okay, already on a quality or a quantity or something, there is a dispute that is going on. Refer the definition. Okay, definition I have clearly given there. Dispute means, dispute includes any dispute in the form of a suit or an arbitration in respect of quality or quantity of goods or amount of debt or misrepresentation of the goods, etc. On that we will bring a dispute. On a quality or on one anything, there is already an existence of a dispute. I repeat once again. Corporate debtor, whenever he receive a demand notice from the operational creditor, he will give two replies. First one, I will not pay. Second one, I have already paid. Why you will not pay? Because there is already an existence of a dispute. You should not raise dispute. After me sending you demand notice, you should not tell there is a dispute. Already there should be some dispute in existence. Okay. Already dispute must be in existence. When the dispute should be filed before receipt of such notice. Okay, already there is a dispute in the court. Already there is a dispute in the arbitral tribunal. Some dispute is already going on quantity or a quality or a timing or price, etc. Let the dispute get settled. Till then I will not make you the payment. Okay. Or second answer he may give, already I paid here. Already you paid. What is the proof? Electronic transfer or the check that is encashed by you is a proof. I am attaching with the demand notice. Okay. Dispute need not always be in the form of a suit or arbitration. It may be. Dispute through emails may also be taken as valid. Case law summary. Always a dispute means court, a suit or arbitration need not be, because definition of dispute will clearly tell dispute includes a suit or arbitration. Means what? Suit or arbitration may be one of the means of raising a dispute. Okay. Sometimes two parties are there. Corporate email is there. Through the time putting the dispute content clearly. Array, your quality is not good. Your quality is not good. You are not reacting back. That itself is a dispute. Raising a dispute after issue of demand notice will not be protected under section number 8. Okay. Next. Section number 9. 9 comes after section number 8. Number 9 will come after section 8. I also know that. But directly section 9 can't come without 8. That is my meaning. Okay. Section 9 will operate after expiry of 10 days from the date of delivery of notice under section 8, or operational creditor does not receive any payment or notice of a dispute, and then he will file an application before AA for initiating CIRP. Next. That means if no reply is received, okay, no dispute notice received, or no payment is also received, in both the cases, if you don't receive payment, if you don't receive a notice of a dispute properly, in both the cases, I can initiate section number 9. What is the format of application? Section 5. Okay. Attachments along with the application. Attachments along with the application. So, to whom we are applying? We are applying to NCLT. To NCLT, we need to make some attachments. This is a common sense. This is what's our common sense. Listen carefully. How beautiful common sense is involved here. First point. When you will come to section 9, if section 8 could not resolve the point. What is section 8? You will try to resolve the problem within the corporate debtor itself. Within the corporate debtor itself without going to NCLT. First thing, what notice you have given? Demand notice you have given. Who has given? Operational creditor. Would have given which notice? Demand notice. What is the proof? Therefore, first send me the proof of demand notice. Very good. Next one, demand notice is received. You are coming to section 9 saying that you didn't receive any notice of a dispute from the corporate debtor even within 10 days. What is the proof? Demand notice means creditor will give to the debtor, I have a proof. That person has communicated through a postal letter. You are telling that you didn't receive any kind of notice of a dispute. What is the proof? Email you will delete. You will tell that I don't receive. That person will tell, sir, sent mail slate is there. You will tell that sent mail slate is not there. You will tell that I didn't receive any notice. Therefore, I am initiating section 9. Though he really gave you a notice. Therefore, affidavit that no notice is given. If affidavit is proved to be false in later time, you will be liable under Companies Act for section 447. Okay. 447 is what? Fraud. Punishment for fraud, false evidence. Section 448. Will get attracted. Sir, why that will get attracted? Because you are a corporate debtor, you are a company. And operational creditor also, if it is a company, that section will get attracted. Okay. Affidavit that no notice is given by corporate debtor relating to the dispute. Next. Payment, you are telling payment is not received. Okay. Simple common sense concept. First, what is the proof that you gave demand notice? Attach the proof. What is the proof that he didn't communicate? Attach the affidavit that no reply was given. Next, what is the proof that you didn't receive a payment? Therefore, copy of certificate from financial institutions, from the information utility, and any other proof if available. Next, after that, you have an option to propose an IRP. It is mandatory to propose by FC and CD, but it is optional to propose by operational creditors. It is 100% optional whether to have a initiation of or proposal of a name of a RP or not. Next, grounds of admission, grounds of rejection of petition. When the application will be admitted, when the application will be rejected. Common sense. 5 points. If these understand these 5 points, enough, more than enough for the exams. First point, application is complete. Okay, application is complete. Okay, I am writing here. Accepted, rejected. I will write one by one. If the application is complete, if the answer is yes, answer is no. If the answer is yes, application will be admitted. If the answer is no, application will be rejected. Delivery of demand notice. If the answer is yes, application will be admitted. Admission, rejection. Don't see the answer. That's why I'm writing here. If it is yes, no. If the application is complete, admitted. Application is not complete, rejected. Delivery of demand notice. If you make a delivery of demand notice, if your answer is yes, application is admitted. If your answer is no, application will be rejected. Payment made a no, then only application will be admitted. If payment is made already, application will be rejected. Receipt of notice of dispute, no, I didn't receive anything. Application is admitted. Yes, I received. Application will not be rejected. The application will not be accepted, will be rejected. Next one. Pending disciplinary proceedings are there? No, not there. Here it is there. So, yes, yes, no, no, no. No, no, yes, yes, yes. Yes, yes, no, no, no. No, no, yes, yes, yes. This is the answer. 7 days time will be given to rectify the defect. With this we completed section number 9. Corporate debtor himself want to apply through a corporate applicant. Corporate applicant means corporate debtor is an artificial person. Therefore, some natural person will apply. He is called as a corporate applicant. Corporate applicant will apply to AA. Okay, will apply to AA when CD has committed a default. So his default he will know better. Its default it will know better. Therefore, in Form 6 directly it will apply. But even though you tell that you are a worst fellow, I have some small doubt that you are good. Therefore, attach the relevant books of accounts which prove that you are unable to pay the amount and name of the RP who is acting as a IRP. Now, very, very important. Sir, corporate debtor is generally a company or a LLP. In a company, you are applying yourself for insolvency. Okay, you will not ask your shareholders. Therefore, if the corporate debtor is a company, special resolution. If the corporate debtor is a LLP, approval of the 3/4 of the partner is required in order to make an application under this particular section. If there is any defect within 7 days, it will be rectified. The date on which the application is admitted, it will be taken as a date of admission of petition of CIRP. Okay. We now completed section number 7, 8, 9 and 10. So hope everyone understood the concept clearly. Everyone in the class, hope you understood the concept clearly up to here. We completed section 1 to section 10. One part is completed. So hope you completed, everyone. Understood the concept clearly? Okay, next one. So next one. So we now completed section number 7, 8, 9 and 10. Okay, 7, 8, 9 and 10. Now listen. Suspension of CIRP under section number 10A. Suspension of CIRP under section number 10A. So see here. No application for initiation of CIRP of a corporate debtor shall be filed for a default. This is a section 10A amendment point actually. Not latest, one attempt before. But not asked in exam. Therefore, this is important for us. Suspension of initiation of CIRP. Section number 10A. No application for initiation of CIRP of a corporate debtor shall be filed for any default arising on or after 25th March 2020 for a period of 6 months or such higher period. Okay. No application shall be ever be filed for initiation of CIRP for the default during said period. Next, the saving as provided aforesaid shall not apply to any default committed before 25th. 25th means 25th March. So first let us read. No application for initiation of CIRP of a corporate debtor shall be filed for any default arising on or after 25th March 2020. See here. 24th March lockdown. Complete lockdown was announced for the first pandemic. Government came to know about a reasonable understanding that most of the business houses are going to become insolvent in the near time because of this particular issue. Therefore, any debts defaulted between, use my words and listen to my words properly, any debts defaulted, not debts arising, any debts defaulted between 25th March ending with 6 months, actually it is up to 31st December it was extended, okay, that's why such higher. So 25th March to 31st December, during this period any debt arising is not the point, any default, that means debt was given 5 years back, due date came between these dates and become defaulted, CIRP cannot be filed against them, no application can be filed. Okay, sir, after December 31st can I file? Ever be filed. No application shall ever be filed. Nowhere in the life of IBC you can't bring CIRP for the default amounts during this period, even if it is 100 crore. Why? Pandemic affected them. They are not intentionally doing the fraud. Okay, but once, sir, default committed before 25th March, sir, but continued during 25th March, those are subjected to CIRP. Overaction of the, that means only defaults occurring because of COVID-19 only will be what to say, this protection will be there. Shield only for the defaults during the COVID period. Before COVID only, if you get defaulted, why I have to protect you here? Okay. So the saving as provided aforesaid shall not apply to any default committed before 25th. So hope everyone understood section number 10A. Hope everyone understood section number 10A. So everyone understood the concept clearly? Okay. Next one. So special provisions for PPIRP. When we come to PPIRP, we will discuss about these 2 points. Anyway, heading itself is special provisions with respect to PPIRP, but this is normal only. That's why I discuss this first. Okay. Time limit. So this is very important. So many students will be asking one common doubt in this area. Let me break this. See here. Time limit and withdrawal of application. Time limit. Section number 12. General time limit. CIRP shall be completed within a period of 180 days from the date of admission of application. Extension. First COC will be instructed by RP. That means RP will be instructed by COC. COC will instruct RP. RP will go to AA and ask for extension. Extension can be given only if the 66% of voting share of COC applies for that. And RP will apply to the AA, and AA may give an extension beyond 180 days. How many days it can give? Not exceeding 90 days it can give an extension. Okay. Next. After that, the total period has to be completed. Total CIRP should be completed within 330 days. Sir, so many people ask the same kind of doubt. Sir, extension can be given only once, sir. That was very clear. See here, extension for a period of CIRP shall not be granted more than once. Means what? Extension can be given only once in the lifetime of one CIRP. Now my question is, generally the time period is 180. You may give an extension of a maximum period of 90. Then it should become 270. But here it is 330. What is that 60 days? Tell me. What is that 60? Today is Sri Ramanavamina, only on liquid diet. Morning 6 hours class. After this one. That's why after class I went to hotel and again I came back. I'm in Chennai now in KS Academy, taking classes for CA Foundation and Inter. Morning 7 o'clock to 1:30 class is completed. I went back and again came back to the studio because I have to borrow the studio. This is not mine, na? So that's why. And today Sri Ramanavamina. Happy Sri Ramanavami everyone. Jai Sri Ram. So we are on a liquid diet today. Sir, anyway. Okay. Sir, so many persons have given their own answers with regard to this court proceedings, etc. So listen carefully. So generally a time of 180 days will be given. Plus 90 days of extension will be given. Totally how many days? 270. Totally how many days? 270. Now, additional 60 days will be there. Wrong answer. This is not 60. If it is 60, he would have clearly said like this 90. It is not 60. Do you know what does it mean? 180 days is a time period for the resolution professional and committee of creditors to complete their process. Once their process is completed, CIRP will be started. CIRP will be completed. From the completion of CIRP, implementation will start. That implementation, everything should complete within 330 days. Do you know what does it mean? 180 days we have to generally complete. I completed in 180 days. Even if you complete in 180 days, total CIRP will be completed within 330 days only. Then how come 330 minus 180 become 60? Then 150 days time is there in between. Therefore, that is not the idea, sir. 330 days is a time limit for NCLT to complete. It is a maximum time period given for NCLT. Clear, everyone? Recently also we have to, we are now ongoing with one of the insolvency case. It is now going. Cesar Glass Private Limited. Now we are going for a merger with the Saint Gobain. We are planning for that. So now our petitioner, those for whom we are representing now, so we are now arguing that we will go for a merger with the Saint Gobain. Saint Gobain will be taking over this particular Cesar Glass Company Private Limited. Okay. So that Cesar Glass Company Limited become insolvent in Vijayawada city. So now we are going for an insolvency petition for that. There also legal proceedings will go on. Along with that legal proceedings and all other things put together, NCLT has to complete its work within 330 days. But your work you should complete within 180. Okay. So this is the point. So this is the point. So the main point that everyone has to understand is, this is the basic idea. It is not an extension. It is a time limit for completion by the NCLT. Even if you completed 100 days, 230 extra days will be there for NCLT to complete this particular process of CIRP. Okay. Implementation also should be complete. That's the idea. Withdrawal of application admitted under section number 7, 9 or 10. Sir, can the application once agreed and accepted, can we withdraw? Yes. 90% of the voting share is required. Next issue. Section number 13, 14, 15, 16. 13 is a parent. 14, 15, 16 are the children. It's a mother of all these three sections. Do you know why? Section 13 is a charging section for 14, 15, 16. AA, after admission of application under section 9, 10, 7, 9, 10, three things he will do. Declare moratorium, make public announcement, appoint IRP. Appoint IRP. Sir, in the public announcement, what we give, we will write the name of who is IRP. Then, first which section we need to read? IRP section we need to read first. That means IRP appointment will be made. His name will be given in the public announcement. That means technically 15 section and 16 section will be, one is a predecessor, another one is a successor. But originally when we come into the practical scenario, first IRP will be appointed, later only public announcement. So that's why public announcement shall be made immediately after appointment of IRP. Okay. Declare moratorium, appoint IRP, make public announcement. Okay. Let us see. Sir, moratorium, keep it aside. I will refer that in the next page. Public announcement of corporate insolvency resolution process. Very important point. Examinationally it may not be asked, but important because claim starts from that day. If you don't give the public announcement, how come other operational creditors and some migrant financial creditors will know about this? Point hai. So how come they will know? Therefore, to make their individual claims, they should first get the information that one of their creditor is and one of their debtor is under insolvency. Therefore, first, contents of public announcement. Name and address of corporate debtor against whom, authority under which it is incorporated, name of ROC, ROC Hyderabad, ROC Chennai, ROC Coimbatore, which one? Next, last date for submission of claims and details of IRP. That's why I said this. And penalty for misleading claims. You need to give all the details. Next, the date on which CIRP is going to close. You should clearly tell that, Babu, this will continue only for 180 days. It will not be for indefinite period. Okay. Next one. Appointment of IRP. Very easy section. If the applicant is a financial creditor or a corporate debtor, okay, then they must have proposed the name already. That proposed person will become, okay, shall act as IRP, provided no disciplinary proceedings pending. But if it is a OC, but this OC has proposed the name, then same point will apply. Okay, provided there is no disciplinary proceeding. If the name of RP is not proposed, first AA will recommend to the IBBA. IBBA within 10 days of the reference will recommend the name of a IP to act as a IRP. Okay, so first note, AA shall appoint IRP within 14 days from the insolvency commencement date. Insolvency commencement date of admission of CIRP. From the days, within 14 days, adjudicating authority shall appoint a IRP. The term of IRP shall continue till the appointment of main RP under section 22. Not for 30 days, not for 40 days. Till RP is appointed, IRP will continue. Okay. Now, the concept of a moratorium will come. See here. Let me explain the concept of a moratorium. Moratorium means a temporary ban. Sir, up to here. Akshay Balaji, are you in Chennai? Yes, I am in Chennai, West Mambalam. I am in West Mambalam, KS Academy. I am now sitting in KS Academy studio. Sorry, anyway, let us start. Moratorium. So what is this concept of moratorium? Let us see. Who shall order declaration of moratorium? AA on insolvency commencement date. AA on insolvency commencement date will declare a moratorium. Moratorium means a temporary ban. Temporary ban on what? Ban on four things. These are the four important things that we need to understand. There is a temporary ban on four important issues. What are the four important issues on which the temporary ban is there? Number one, you can't file new legal suits. Existing legal suits can't continue. Number two, physically assets cannot transfer. Any form, either transfer, encumbrance, alienation, disposal, you can't transfer. Banks are one of the financial creditors. Banks have given secured loans to the company. Our corporate debtor has accepted loans from hundreds of people. In that, one of the person is a bank. Bank has given loan on a security. Now, since the default is made, bank is telling that I will take that asset. Law is telling bank, you are not an exception. Don't do overaction. Come in a line. Queue is there already. Okay, in that queue only we should come. Just because of the reason that it is a security interest asset, you can't take it because the CD is under subjected to moratorium. Next one. Acquisition of leasehold properties. Leasehold properties on the balance sheet also should not be transferred to the lessor. Why? We doubt that it is not a leasehold property. Just you labeled it as leasehold property such that that asset will not be taken for liquidation. Therefore, moratorium on 4 things. Number 1, existing legal suits can't continue, new legal suits can't be filed. Transfer and encumbrance or disposal of assets not possible. Number 3, banks cannot exercise their security interest enforcement. And last one, leasehold and rental properties also cannot be transferred. Next, no moratorium on what? No moratorium on no transactions notified by CG, and no moratorium on sureties properties. Okay. Next, upon consideration of IRP or RP, first point, even though moratorium is there, supply of essential goods and services will not be stopped because going concern should not be affected. Okay. Special cases. Any license, permit, registration, quota, all kinds of intangibles given in the name, licenses, etc. Those will not be moratorium because, for example, I have a mining quarry is there. Quarry will run because of a government license that is given to me. If you take the license, quarry can't run. That means the quarry will run because of the license given. Therefore, this is directly related to my going concern assumption. Therefore, the license, permit to quota, etc. will not be suspended or terminated. Moratorium shall be continued till the date of CIRP. Answer completed. Okay. With this, we completed section 13, 14, 15 and 16 as well. Everyone, please give an answer. Understood the concept clearly? Up to here. Sir, next very, very important concept. I am starting with committee of creditors. Next topic, I am starting with committee of creditors. Very, very important. So let's start. So after this, management of affairs of corporate debtor by interim resolution professional. Interim resolution professional will manage the affairs of whom? Corporate debtor. Management of affairs of corporate debtor by the interim resolution professional. Interim resolution professional will stand as a management person. All the existing board of directors will be suspended. He will commence it. Therefore, what they would have done, he will do now. What they will do? What they would have done? All deeds and documents will be executed by them once upon a time. Now he will do. Okay. Next, take any actions as may be specified by board. IBBA will give some instructions. He has to do that. Generally, electronic records of IU, generally access to the records of the government with related to company, PF documentation, etc. Everything will be done by board of directors. Now he have an authority to access the books of accounts, etc. Okay, and he also have a responsibility to comply with any law. Means what? IRP job is not that easy in a company. We are now doing now. It is not just like going into company and managing the company. Try to understand. We need to comply with various laws available and applicable to that particular company. That's why when we write the IBBA examination, limited insolvency exam is conducted to qualify the insolvency professional course. There, one of the syllabus content, if you see, 60 marks from the insolvency code. 60 marks from insolvency code. Okay, remaining will be contract act, sale of goods, partnership, companies act, all these will come. Everyone will wonder why these are applicable for our syllabus. Simply, whenever company has to run as a going concern, you need to enter into contract. For that, you need to have a contract act. Goods sale, sale of goods act. Therefore, a person sitting as a IRP should not just sit like a rock. He should have a knowledge of all the laws applicable to that company. Not only that, whatever the board would have done previously, it will be suspended and excised by IRP. Officers and managers and other employees of the company usually report to the board of directors. Now they will report to the insolvency resolution professional. Okay, so they shall report to IRP and shall provide document. Financial institutions will give information only to the board of directors. Now you should give to the IRP. Next one, very important section. Committee of Creditors. What is the section? Section number 21. Committee of Creditors. Section number 21. So what is this Committee of Creditors concept? What is so great about this? What are the amendments that were brought inside? Let's try to understand very clearly in detail. See here. See here, everyone. Okay, let us start with the concept. So see here, everyone, we are going to start with the most important concept in this particular area. This area will be called as a Committee of Creditors. Which concepts are Committee of Creditors? Very important section in the syllabus. Okay, see here, let us concentrate on understanding what is this concept of Committee of Creditors. Sir, Committee of Creditors concept is very important in the sense so many questions can be asked in this examination with regard to this area. Committee of Creditors is, this is the point. This is a continuity to Committee of Creditors concept. Okay, continuation to the Committee of Creditors. Later related provisions will be there. Directly we will go to the next concept, authorized representative, like this. We will complete first till the start of this concept called as a liquidation. Up to there we will be completing first. Okay. So let us start with the concept Committee of Creditors. Who shall constitute the Committee of Creditors is a question now. Who shall constitute the Committee of Creditors? IRP will constitute Committee of Creditors. Who forms it? After collation of all the claims, all claims will be received under section 15. From that claim, two types will be there: financial debt, operational debt. From that, financial creditors, financial debts I will take. Operational, I will sort it out. Okay, this financial debt persons are called as financial creditors. These people will form the committee. Okay, after determining the financial position, will form a Committee of Creditors. Committee of Creditors will be formed after collation of all the claims. Next, composition of COC. COC shall comprise of financial creditors of a corporate debtor. Who will not be there? Operational creditor. Reason, already I have made one video on Committee of Creditors once upon a time. There I said the reasoning. Please look there. Okay, already in the YouTube channel there is one video on Committee of Creditors. You can see there. Okay, na? Okay, next issue. Inability in certain, why operational creditors will not be there? I explained there very clearly. Inability in certain cases. Okay, see here. Condition. Financial creditor or its authorized representative is a related party to the corporate debtor. Is a related party to the corporate debtor. Okay, listen carefully. Inability in certain cases. What inability? Listen carefully. Every financial creditor will have three rights. What rights? RPV, not RGV. What is this? RPV. Represent, participate, voting. Three powers will be given to all the financial creditors in the Committee of Creditors meetings. They will have a right of representation, they will have a right of participation, they will have a right of voting. But they are unable, and inability will come in certain cases. Condition. Financial creditors or its authorized representative is the related party to the corporate debtor. Corporate debtor is sitting there. Financial creditor representative is sitting here. That financial creditor's authorized representative is a related party to corporate debtor. Why he will pass against him? Therefore, that person will not be given a chance of RPV. Shall not have a right of R, shall not have a right of P, shall not have a right of OV. completed. However, there is an exception to this. That means even if a financial creditor is a related party to the corporate debtor, even in that case voting chance will be given, provided these conditions are satisfied. What are these? Let's see. There is a financial creditor. Such a financial creditor is regulated by financial sector regulator. Such a financial creditor is a related party to corporate debtor. Such a relation has emerged solely on account of conversion of debt into equity shares or instruments converted into equity prior to the insolvency commencement date. If all the conditions are satisfied, FC has a right of RPV. But you read all the 4 conditions first. Read all the 4 conditions. Complete live complete insolvency code chapter. Okay, see here now. There is a financial creditor. Such a financial creditor is regulated by a financial sector regulator. Such a financial creditor is a related party to the corporate debtor. Such a relation has emerged solely on account of a conversion of debt into equity shares or instrument converted into equity prior to the insolvency commencement date. So there is a financial creditor. Such financial creditor is regulated by a financial sector regulator. First, there is a financial creditor. For example, let's say SBI, regulated by financial sector regulator RBI. This particular SBI became a related party to the corporate debtor. Why it became related party to corporate debtor? Listen carefully. Once upon a time, prior to the insolvency commencement date, let's say in the year 2010, in the year which year? 2010, corporate debtor has taken loan from SBI in 2005. Due for repayment in the year 2010. Corporate debtor is X Limited. X Limited being corporate debtor has taken loan in 2005, which is due to pay on 2010 from S to SBI, but corporate debtor failed to repay that. Because of failure to repay, SBI has various chances at that time. But what it has done, corporate debtor is a very good company. Therefore, what the SBI has done, SBI said that you do one thing. I will not take action against you, but you one thing. Whatever the amount of debt due is there, to that extent, issue as equity shares. Issue as what shares? Equity shares. Once the equity shares are issued, SBI will become the owner of that company. Owner means one of the owners. Good amount of control will come in the ownership or not. Therefore, there is SBI regulated by RBI. SBI is a related party to the corporate debtor. Now, why that relation exists? Such a relation has emerged solely on account of, means what? Only because of conversion of debt into equity, not because of interest of SBI on that company to purchase. It didn't purchase in the open market. Because of conversion of your debt into equity, I acquired the shares. Because of acquiring equity above 20%, then related party definition will get attracted. Thereby I became a related party. In that case, I didn't become a member intentionally, but because of conversion of debt into equity, no problem. If all conditions are satisfied, that SBI will have right to represent participator voting in the meetings of the committee of creditors. Okay, next one. Forming COC in the form of, in case of consortium financing. Okay, what is consortium financing? It's called as a syndicate financing. Okay, the word syndicate financing is not Pushpa dialogue. Really, it is called as syndicate financing. It is found in IBC only. You will find there. Okay, they will form a syndicate. Okay, syndicate Pushpa Pesare, not that syndicate. This is a syndicate for financing. It is really there in the law. Law used words only. These are not fabricated phrases. Sorry. Condition number 1. Corporate debtor owes financial debts to 2 or more financial creditors. That means corporate debtor is owing not only to one person, to 2 or more financial creditors. Condition 2. Such a financing is a consortium. Such a financing is a consortium. Consortium means what? In a group, in a batch. Okay? In a batch, it is lent. So, 5-6 banks came together and lent money to one single party. That one single party is a corporate debtor. 5-6 banks will become the multiple financial creditors, forming a syndicate or a consortium. Now, see here. Bank 1, Bank 2, Bank 3 has given loan on a consortium agreement to one corporate debtor. Now, corporate debtor committee of creditors is formed. Who will go? Bank 1 will go na, Bank 2 will go na, Bank 3 will go na. Who will go? Each one of them will have their own representatives to say. Bank 1 representative will go, Bank 2 representative will go, Bank 3 representative will go. Based on how much loan they have given, in that proportion voting rights will be given there. Okay. So each financial creditor shall be a part of COC and voting share is on the basis of their financial debts. Okay. Next. Dual capacity. I am both the financial creditor and operational creditor. Then in case of incapacity, the financial creditor shall be included. Incapacity of the operational creditor shall not be included. Assignment of debt. Where operational creditor assigned operational debt to FC. What will happen? In capacity as FC, I shall be considered as a financial creditor. In capacity of a OD, in transfer of that, I will be called as an operational creditor. Special circumstances. Authorized representative type 1 we seen in section 7. That one financial creditor can appoint authorized representative. Here we have seen banks are there. 7 banks will be there. 5 or 7 or 10 or some banks will be there in a syndicate. Each and everyone can have their own authorized representative. Next. Special circumstances. Here third one will come. Where there is a consortium financing providing for appointment of single trustee. Appointment of a single trustee. Where there is a consortium financing provided for appointment of single trustee. Now, Bank 1, Bank 2, Bank 3 appointed only one single trustee. One single trustee. That person is, let's say, Mr. A. Mr. A will be an authorized representative for whom? Both A, B and, Bank 1, Bank 2 and Bank 3. All the three, that person is the only single trustee. This person only will do RPV. This person only will do what, sir? RPV. So who will do the RPV work? This particular person will do the RPV work. Which person? That person, Mr. A, on behalf of the consortium, he will be the single trustee. That means while giving the loan itself, while giving what, sir? Loan itself, they have clearly said that consortium will not have individual authorized representative. All the three will have a common authorized representative. Then you can have like that. Okay, then B1, B2, B3, all the three will have one common authorized representative. Who is that? Mr. A. That person is called as a single trustee. That single trustee will act for all, will act for each. All the three will appoint one trustee, but that one trustee will act for each of them. That means he will collect the information from all the three. Bank 1, whether in the meeting, what I need to talk on your behalf, which resolution I need to pass, favor or against, clearly write the paper and give it to me. Bank 2, you also tell me the instructions clearly. You want me to pass the resolution in favor or against. Bank 3, you also tell the same. I will collect and collate all the information and then go and sit in the meeting and pass resolution as per the instructions given. Then, where there is a consortium financing provided for appointment of a single trustee or agent on behalf of all financial creditors, then each financial creditor may authorize a trustee or an agent to act on his behalf. Authorize a trustee or agent to act on his behalf in the COC. Authorize a trustee to act on his behalf in the COC. Represent himself in the COC. Okay. Sometimes I think that representation of that single trustee is not that correct. I want to appoint one good person having knowledge in insolvency code to sit on my behalf for representation work, not for voting work and participation, only to represent me. I want some other person. I will put one good advocate, or I will put a insolvency professional. Appoint any insolvency professional not being a resolution professional to represent him in the COC at his own cost. Okay. I repeat, consortium is there. Consortium, banks are lending to one particular financial creditor. In a group, they are lending the money. In a group, when they are lending the money, they have two options. In the first case, wherever you discuss here, last point. In the first case, this is the first case for us. Here, they appointed one authorized representative for one bank inside the consortium. In the second case, it is not like that. They agreed for a single trustee already. That single trustee only will represent. But one of the bank inside that thought that single trustee can't speak properly in the meeting. Therefore, at my own cost, I will appoint an IP who is not a RP to go on my behalf and represent. Okay. Next issue. This is authorized representative type. That is type number 1. Okay. Previous one is a type 2. This is a type 3. 4, 5, 6 also will come. Listen carefully. If the financial debt is in the form of, securities like debentures, then what will happen? Debenture trustee will be appointed as an agent for all of them. That debenture trustee will not act for each of them. He will die. 25,000 debenture holders are there. Then such trustee shall act on behalf of all such financial creditors, where financial debt is owed to the creditors exceeding such number. Which number? Listen, this is very, very important point. I repeat, financial debt is in the form of debentures and deposits, etc. Debentures, if they are issued, 25,000 debenture holders are there in the company. One debenture trustee will be appointed. That one debenture trustee will act according to the instruction of each and every person. He will die. Therefore, he will not act for each and every one. He will act for all of them in detail. Okay, for all of them I will pass one resolution that applies to entire debenture holders. Next one, where the financial debt is owed to the creditors exceeding such number. Okay, what is this? Real estate allottees. If the real estate allottees number is increased so much, there are around 100, more than 100 we have seen. If the number is exceeding 100 or exceeding 1/10 or 10% of the total real estate project, if the number is exceeded, listen carefully what will happen. Where the financial debt is owed to the creditors exceeding such number, like real estate allottees are there, directly they cannot form part of the committee of creditors. Authorized representative they have to appoint. In case of debenture trustee, there is a benefit. Do you know what is the benefit? The company which is issuing the debentures will only propose the name of debenture trustee and appoint them. You need not, again, debenture holders need not separately appoint them. But in case of real estate transaction, there is no real estate trustee. Therefore, who should appoint? Real estate allottees should appoint. Real estate allottees, how they can appoint? One person will be in Mumbai, one person is in Hyderabad, and one person is in Chennai. They will just put an investment in that particular property. In such case, how they appoint? Therefore, lawmaker understanding this problem, do you know what he said? IRP will first make an application to the AA, along with the list of financial creditors and the name of IP other than IRP, who shall act as an authorized representative. And such authorized representative shall be appointed prior to the first meeting of COC. Means IRP shall make an application to the AA. To whom, sir? AA. Along with the list of financial creditors and the name of IP other than IRP, who shall act as an authorized representative. That means who will act as authorized representative on behalf of the real estate allottees? One insolvency professional will come and sit on their behalf. That insolvency professional name will be requested by the IRP itself. Last one. If the financial debts are in the form represented by guardian and executor in the name of minor, in the case of insolvent creditor, if there is anything like that, then the guardian and executor shall act as an authorized representative. These are all the main points in section number 21. So summarize everything, we need to understand one very important point. There are 6 types of authorized representative. One financial creditor can represent himself with an authorized representative. Second one, consortium lending, like each bank can have each authorized representative. Third one, consortium lending provided for single trustee. All of them will have only one person, but that one person will act for each of them. Fourth one, if it is in the form of securities and debentures, one debenture trustee will be appointed for all of them and he will act for all of them. Real estate transaction, if it is exceeding such particular number provided in that particular rules, if that be the case, IRP shall make an application to AA to recommend the name of a IP who will act as an authorized representative on behalf of the realtors, because real estate allottees can't make the appointment of that particular RP or IRP as the case may be. Or executor or a guardian, minor or insolvent person is there, then guardian or executor shall act as an authorized representative. This is all about the concept of committee of creditors. Sir, up to here everyone understood the concept clearly? Sir, all important points were kept in the material. Okay, all important, whatever I felt important in this particular area on COC, Everything was kept, whatever is important was kept here. Okay, but one small change you need to make, sir. One small change. All decisions taken by COC shall be taken by vote of 75. This is a wrong one. 51. Not 66, 51. Generally, Committee of Creditors shall take 51% decision making. If 66 is said, follow 66. If 90 is said, follow 90. Nothing is said, only Committee of Creditors said the 51. Please make a change. By mistake, it was there. Okay. So these are all the main points, sir, that we need to remember in this particular COC concept. Okay, in this COC concept. These are all important points that you need to remember. Okay. So the main half portion of the insolvency code has been completed with this. Another half portion is there. In that half portion, we will complete of the PPIRP, FTCIRP and certain other basic concepts. With that, we will be completing of this entire IBC. Main concepts for paper 4 and common bit between paper 6. Paper 6D la, after paper 4 concept, only 31 sections are there. Dead easy, directly we can read and go. Main conceptual sections, only paper 4 is important for even for paper 6D. After that, up what are the qualifications of IRP, those you can also see and write in exam. Anyway, it is open book paper. Problem is only with the paper 4 syllabus, even in the paper 6D. Because in syllabus content, whatever is given, 60% of the portion, case laws, everything is coming from paper 4 only, even in paper 6D. Therefore, whatever we discussed till now, and another 8 sections are there, those sections, all these in a consortium will be forming part of substantial portion, even in case of paper number 60. Okay, sir, one small thing that I have to tell, if you have any doubts, you can ask me. But I have to close the session because in 2 hours another person has to come and he has to record. Tomorrow another session will be there on insolvency code. Live or directly I will put a video, I will announce you, and I am giving you a word. IBC remaining portion also will come to you. Okay. So because 2 hours is complete, I have taken for 2 hours, another person has to record now. So they are waiting outside. So I am completing here. Remaining portion of the insolvency code in 2 hours, maximum main concepts I have covered. Balance portion, if any, also I will cover. Okay, tomorrow only I will cover. Maximum tomorrow only. The upload also will be completed for that. Okay, remaining portion including PPIRP. Maximum possible I will come live because I am having various obligations. So fast track batches are going on, full batch recordings are going on, inter batches are going on, foundation batches are going on. So what I can do is I will come only live, or else I become lazy once I go home. So I will promise a live only, because in live means at least students will be there, I can interact and I can complete of the syllabus. Okay. So insolvency code after, I will be taking the 6D case laws. So such that people who are also writing for 6D will get benefited out of it. Okay. Amendment video only I will record, Mr. Rohit. Yes, definitely. I give a promise to you. PPIRP tomorrow we will complete, including amendments. Okay. So we will complete. FCRE amendments also I will cover from the charts. Okay. FCRE amendments also I will make a chart. Okay. Surface also we will discuss. I already told you those areas. Okay. Yes, 6D recordings are there. Okay. Anyway, this is not the time to talk about my classes, recordings, etc. So if you have any doubt, you can put me a message. But still, everyone, sir, please listen to this lecture once for all. Committee of Creditors concept, please mark it very, 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 very important for the coming examinations. Okay. Any doubts in this regard? Any doubts in this regard? If you have any kind of doubt with regard to this concept, you can put your doubts. Okay. Put me personal message if you want. I can clarify, or else better in the YouTube live itself. If you have any doubt, you can ask. I will clarify the doubts and I will leave. So like bank revoke the shares, put again as a loan, those are converted. Main doubts I will cover. Sir, FD holder is not paid, like in case of FD holder, okay, can be called as financial creditor. Yes, financial creditor. But if the bank or NBFC is there, NBFC's act is applicable, but the bank absolutely not applicable. Yes, sir. Tomorrow session PPIRP I will cover. FCRA amendments are there, I will cover. Okay, surface. So PPIRP anyway, charts are also available. I will explain you the idea behind PPIRP clearly and I will complete live. Hardly 30-35 minutes sir, PPIRP, not more than that. Okay, beyond that it will not take any time. So thank you very much sir. Tomorrow we'll meet again. Live only I will come because I become lazy once I go home after so many hectic schedules. So I'll complete and then only I will be going into the next one. Okay, so thank you very much guys. Hope you are all preparing well. Thank you very much. Again in another live session we'll be meeting. Clear? So thank you.